$340,000. That's what it costs me to learn her real name. Not Denise Whitfield, not Denise Coltis, not any of the 7 names she'd used across 4 states over 11 years. Her real name, the one on her original birth certificate, the one investigators eventually pulled from a sealed record in Ohio, was Diane Marie Coltis. And by the time I learned that name, she had already drained my mother's fully paid-off house through a reverse mortgage she arranged herself, forged a power of attorney using my dying mother's shaking signature, and moved herself into our family home so completely that when I finally called the police to remove her, the responding officer looked at the lease she handed him, a lease she had forged in one afternoon at a UPS store, and told me, and I quote, "Ma'am, this looks like a civil matter. You'll need to file for eviction." She had been living in my mother's house for 6 weeks before I even knew her legal name was fake. She had been stealing from my mother for over a year before that. She thought she got away with it. She was wrong. This is the story of how a woman who specialized in exploiting grieving families picked the wrong one, and how a forensic accountant, a notary journal nobody thought to check, a stubborn detective, and 18 months of nights I couldn't sleep turned into a criminal conviction, a civil judgment, a house returned to my family, and every single dollar accounted for. My name is Lauren Mercer. I'm 44 years old. I live outside Sacramento, California. And until 3 years ago, I thought financial predators were the guys who call pretending to be the IRS or the romance scammer messaging a lonely widow on Facebook. I didn't understand that some predators are far more patient than that. Some of them don't call you from overseas. They show up at your door with casseroles and references. They learn your mother's medication schedule. They make themselves indispensable, and then they make themselves permanent. Today's story is about greed, betrayal, and getting every single dollar back, plus the education I wish someone had handed me before my mother got sick. Because if you have an aging parent, a family property, or an inheritance anywhere in your future, what happened to my family could happen to yours. If you're new here, this channel documents real financial fraud cases from discovery through sentencing, the scams, the schemes, the paper trails, and the moment predators finally answer for what they did. If that's your thing, subscribe now because we follow these cases through the entire legal process: police report, forensic accounting, civil suit, criminal trial, restitution. Let's start at the beginning, because the woman who eventually forged my mother's signature on a $120,000 home equity line of credit didn't break into our house. We let her in ourselves, and it took me the better part of a year to understand exactly how. To understand how this happened, you need to understand exactly where my family stood in the spring of 2022. My mother, Carol Mercer, was 78 years old. She'd lived in the same house in Fair Oaks, California for 31 years, a 3-bedroom ranch house my father built equity into for 2 decades before he passed away in 2015. By 2022, that house was worth close to $650,000, and it was, on paper, the single largest asset my mother owned. She had roughly $210,000 in a rollover IRA, a small pension from my father's years at the railroad, and Social Security. No debt of any kind, no mortgage. She had paid the house off in full in 2009 and thrown a small party about it, and I remember her joking that the deed was the only thing in her life that was ever completely, unambiguously hers. Then, in March of 2022, she was diagnosed with stage 3 pancreatic cancer. I want to be honest about what that diagnosis does to a family, because it matters enormously to everything that came after. My mother went over the course of about 6 weeks from an independent, sharp, occasionally stubborn woman who did the New York Times crossword in pen to someone who was in and out of Sutter Medical Center every 10 days for chemotherapy, exhausted, nauseated, in pain. And this is the part predators like Diane Coltos are trained to look for. Increasingly alone during daylight hours because I was working full-time 40 minutes away in Roseville, and my brother, Kevin, was in Denver with 2 kids and a mortgage of his own. We needed help. Specifically, we needed reliable in-home care during the hours neither of us could be there. And like a lot of families thrown suddenly into that situation, we didn't start with an agency. We started with word of mouth because word of mouth felt faster, warmer, more human than calling a franchise home care company off a billboard. A woman from my mother's church, someone I'd known only peripherally for years, a kind, well-meaning woman named Pam, recommended a caregiver she said had helped her own mother through the end. Pam wasn't lying to me. Pam was genuinely helped. That's part of what made this whole thing so effective. The referral chain itself was sincere, even if the 100% dedicated caregiver named Diane Coltos ended up having a 98.7% chance of plunging my family into ruin. The person at the center of it wasn't. The caregiver's name, the name I knew her by for the next 14 months, was Denise Whitfield. Here's red flag number 1, and I name it clearly because I missed it completely. Legitimate in-home caregivers in California are generally expected to register with the Home Care Aid Registry through the California Department of Social Services, and licensed home care organizations are required to run background checks through the Department of Justice and FBI databases. I never asked to see her registration. I never ran a background check of my own. I trusted a referral from someone at my mother's church because grief and exhaustion make you want to trust people rather than investigate them, and because it felt almost rude in the middle of a cancer diagnosis to ask a kind-seeming woman for her fingerprints. Denise showed up for the interview polished, warm, and, I want to be fair here because it's true, genuinely good at the job, at least in the beginning. She knew how to talk to my mother without being condescending. She used phrases like activities of daily living and medication reconciliation that made her sound trained and credentialed, even though we never actually verified any certification behind those words. She said she had worked privately for families in Granite Bay and El Dorado Hills for years and preferred not to go through an agency because, in her words, agencies take 40% off the top and don't care about the client the way I do. Red flag number 2, in hindsight, so obvious it's almost painful. Caregivers who actively steer families away from licensed agencies are steering you away from the one system with any real chance of catching them. We agreed to pay her $28 an hour in cash, 4 days a week. Over the following months, that arrangement grew the way these things tend to grow, gradually, reasonably, one small extension at a time. She started staying overnight in case Carol needs something in the night. She started handling my mother's mail so you don't have to keep driving over just to sort bills. She started attending doctor's appointments alongside my mother, and before long, driving her alone while I covered work. By September 2022, Denise Whitfield was spending more waking hours with my mother than I was. I remember noticing that fact and feeling grateful, not alarmed. That's the part I still have to sit with. I want to share one specific conversation from that month because I've replayed it more times than I can count. I called my mother on a Tuesday evening and she sounded lighter than she had in weeks. She told me, "Denise reorganized the whole kitchen today. She said it'll make things easier for me when I'm too tired to think." I remember feeling a wave of relief so strong it was almost physical. Someone competent was handling the thousand small logistics of a household I couldn't be present for every day. I said, "That's wonderful, Mom. I'm so glad she's there." I had no idea that reorganizing the kitchen also meant relocating my mother's checkbook, a folder of account statements, and her address book to a drawer only Denise had easy access to, ostensibly to keep things tidy. Denise also did something I now recognize as a deliberate strategy, though at the time it read as simple thoughtfulness. She began handling communication with my mother's other longtime friends. She'd tell people at the door, kindly, that Carol was resting and would call them back, and then sometimes she simply wouldn't pass the message along. Slowly, over months, my mother's social circle narrowed to essentially 2 people, me, on the days I could visit, and Denise, every single day. Investigators later confirmed through interviews with 2 of my mother's closest friends that this exact narrowing pattern had also occurred with both of the other known victims in Citrus Heights and Rockland, a documented, repeated tactic, not an accident of circumstance. There's a term for this that I learned much later from an elder abuse prevention specialist I interviewed for my own research: coercive isolation. It doesn't require locking anyone in a room, it just requires slowly becoming the only reliable source of company, information, and reassurance in someone's life until that person's entire understanding of what's normal starts running through you. I also want to touch on something my mother and I never got around to before her diagnosis, because I think it's one of the most common gaps in American families, and it was a gap Denise exploited with precision. We had no formal estate plan conversation, no financial power of attorney set up in advance with someone we trusted, and no shared understanding of who would step in if my mother became incapacitated. My mother had a will, drafted years earlier, and a basic revocable trust from 2016, but nothing that addressed who should manage her day-to-day finances if she became too sick to manage them herself. That gap is exactly the vacuum a durable power of attorney is designed to fill, and exactly the vacuum Denise filled first, before either my brother or I ever thought to ask the question. Financial planners and elder law attorneys will tell you the same thing, and I've since spoken with several for my own peace of mind. The time to set up a financial power of attorney naming someone you trust, a family member ideally, or a professional fiduciary if family isn't an option, is well before any diagnosis, while the person is fully competent and the decision can be made calmly, deliberately, and with independent legal advice. Waiting until a crisis hits means the decision often gets made under duress, under medication, or under the influence of whoever happens to be in the room that day. In my mother's case, that person was Denise. I need to walk through the actual mechanism predators like this use because it isn't dramatic, it's administrative, it's paperwork. Diane Coultas, operating as Denise, didn't need to break any locks or threaten anyone. She needed access to 3 things: my mother's trust documents, so she could position herself near future decisions, a durable power of attorney, so she could legally act on my mother's behalf financially, and my mother's genuine emotional trust, so that when I eventually raised concerns, my own mother would defend Denise against me. She methodically acquired all 3. In October 2022, my mother, weakened, medicated, and increasingly isolated from extended visits because Denise had begun subtly discouraging them. She's resting, let's not overwhelm her today, maybe next week. Signed a document at her own kitchen table. Denise told her it was an updated healthcare directive, the kind of routine paperwork you signed every couple of years for your doctor's office. It was, in fact, a durable power of attorney for finances, drafted from a $40 online legal template naming Denise Whitfield as agent, with broad authority over banking, real property, and retirement accounts. Notarized by a mobile notary Denise herself had located, scheduled, and paid $75 cash. I did not know this document existed until 11 months later. That signature is the moment the money changed hands. Not literally, not yet, but legally. That single kitchen table signature was the key that would eventually open every account my mother had. I want to pause on something here because it's the piece viewers ask me about most. Why didn't my mother tell me? I've thought about this for 3 years, and the honest answer is layered. Partly, she likely didn't fully register what she signed. Chemotherapy brain fog is real, and her oncologist later confirmed she'd been on a cocktail of medications that affected memory and judgment during that exact window. Partly, Denise had spent months building a narrative where I was stressed and overwhelmed, and Denise was the one who actually shows up, which made my mother protective of her rather than suspicious. And partly, the hardest part to admit, my mother was proud and didn't want to burden me with one more decision while I was already juggling a full-time job and her chemo schedule. Predators like this don't just exploit the vulnerable person around them, they exploit the entire family system around that person, quietly repositioning themselves as the reasonable one. I want to give you a few more of the small moments that, looking back, should have told me something was wrong long before my mother died. I'm including these because I think they're more useful to you than the big dramatic reveal, since real fraud almost never announces itself with a single obvious event. It announces itself in a series of small, forgivable seeming inconsistencies. In January 2023, my mother mentioned almost in passing that Denise had helped her refinance something for the house, just to free up a little cash for medical bills. I remember nodding along, relieved that someone was handling logistics I didn't have bandwidth for. I never asked which lender, I never asked to see the paperwork. I told myself that was appropriate boundary setting between an adult child and her mother's private financial decisions. In hindsight, it was the single moment I could have stopped everything that followed, and I let it pass because I was tired and it felt intrusive to push. In March 2023, I noticed Denise driving a car I didn't recognize, a leased gray Mercedes-Benz, and when I asked about it, she said cheerfully that a former client's family had gifted it to her after years of service. It struck me as odd for maybe 30 seconds, and then I moved on, because questioning a caregiver's personal life felt, at the time, like an overstep. In May 2023, my mother's neighbor of 20 years, a retired school teacher named Frank, mentioned to me at the mailbox that he'd seen a notary lady's car parked in the driveway twice that spring. I said something like, "Oh, that's probably just paperwork for her care plan," and again, I let it go. Frank's comment turned out to be one of the most useful pieces of circumstantial evidence we later handed to investigators because it independently corroborated the timeline Raymond eventually built from the bank records. Two separate notarized signings exactly when the reverse mortgage and the haylock were being originated. I share these details because I want to be honest about how ordinary the warning signs looked in real time. There was no single dramatic moment where alarm bells rang. There was a slow accumulation of small, explainable seeming things, each one easy to wave away on its own, that only became terrifying once I could see them lined up together on a timeline. And that's when I found the smoking gun. Except I didn't find it then. I found it almost a full year later, buried in a stack of mail Denise had organized for my mother, a stack she clearly assumed no one would ever look through again. My mother died on August 4th, 2023. I'm not going to dwell on the details of that day here, except to say this. Grief makes you slow. It makes you miss things that should be obvious. And Denise Whitfield understood that better than anyone, because she had been quietly positioning herself for exactly this moment for well over a year. 3 days after the funeral, still numb, running on almost no sleep, I drove to my mother's house to begin the impossible task of sorting through her things. Denise was still there, still living there, and when I asked her, as gently as I could manage, when she thought she'd be able to move out so we could begin preparing the house for sale, she looked at me with an expression I can only describe as calm, rehearsed sympathy, and said something I will never forget. "I'm not going anywhere, Lauren. Your mom wanted me to have this house." I actually laughed. It sounded so absurd that my brain refused to process it as a real threat. And then she handed me a folder. Inside was a quitclaim deed dated June 2023, roughly 6 weeks before my mother died, purporting to transfer a life estate interest in the property to Denise Whitfield in recognition of care provided, recorded with the Sacramento County Recorder's Office and stamped with an escrow. Official recording number. There was also a residential lease agreement, also dated June 2023, in which Carol Mercer agreed to rent Denise a room in the house for $1 a month for a term of 10 years. And there was the power of attorney document I mentioned earlier, the one I had never once seen, dated October 2022, still technically in effect on paper, granting Denise sweeping authority over my mother's financial accounts. I want to give you the real scale of the damage now because it took weeks of pulling bank statements, loan documents, and IRA records to understand it in full. Using the authority granted by that power of attorney, between November 2022 and July 2023, Denise Whitfield had done the following. She arranged a reverse mortgage against the house, a house that had been entirely paid off for 14 years, drawing $85,000, signing the origination documents in her capacity as agent under the power of attorney, with my mother consenting during a mandatory notary video call while heavily medicated, and according to my mother's own oncology records, experiencing documented cognitive fog from her treatment regimen at the time. Roughly 2 months later, she opened a home equity line of credit against that same property for $120,000, drawing the full amount within 6 weeks in a series of transfers into an account belonging to an LLC called Golden Years Home Solutions, an LLC Denise had personally formed just 3 weeks after obtaining power of attorney, registered to a UPS store mailbox address in Citrus Heights. She liquidated $95,000 from my mother's rollover IRA, triggering an early withdrawal penalty that the estate would later have to absorb, and wired the proceeds to that same LLC account. And she withdrew approximately $40,000 in cash over the preceding year, structured in a pattern of withdrawals consistently just under the $10,000 threshold that triggers a currency transaction report under federal banking law, a pattern that investigators would later describe, almost admiringly, as textbook structuring. Total, $340,000. That is not a number I am rounding for effect. That is the exact figure a licensed forensic accountant later certified, dollar for dollar, as the documented loss directly attributable to Denise Whitfield's conduct while acting as power of attorney. I want to pause on the damage here because the number itself, $340,000, doesn't capture the full scope of what this cost my family. There was the financial damage, obviously, which I've already laid out, but there was also relational damage that no restitution order will ever fully repair. My brother Kevin and I, who had always been close, went through a genuinely painful stretch where he questioned why I hadn't noticed any of this sooner, since I was the one geographically closer to our mother. I understand now that was grief talking, not a real accusation, but at the time it strained our relationship badly enough that we barely spoke for almost 2 months. We've since repaired that, and if anything, going through the investigation together, dividing tasks, comparing notes, showing up for depositions as a united front, ultimately brought us closer than we'd been in years. But I want to be honest that it got worse before it got better. There was also the emotional damage of having my memory of my mother's final months colored by all of this. Instead of remembering her last year as a period defined by closeness, difficult conversations, and the kind of quiet bonding that happens when you know time is limited, a significant portion of it is now tangled up in my memory with paperwork, suspicion, and a slow dawning horror about what was actually happening in that house while I was at work 40 minutes away. That's a loss no dollar figure addresses, and it's one of the reasons I've chosen to tell this story publicly, because getting the money back mattered enormously, but it didn't undo that particular theft. My first instinct, and I suspect this is most people's first instinct in this situation, was to try to resolve it like a reasonable dispute between adults. I called an attorney a coworker recommended and asked what it would take to simply revoke the power of attorney and get Denise out of the house. Here's what I learned in that first meeting, and it's a critical piece of law for anyone dealing with something similar. A power of attorney automatically terminates upon the principal's death. My mother had died. Legally, the POA document was already void the moment she passed. That part, at least, was simple. The house, however, was not simple. The quitclaim deed, the one purporting to grant Denise a life estate interest, had been recorded with the county before my mother's death, while the power of attorney was still technically active. On paper, county records showed a facially valid transfer of property interest. Getting Denise out of that house wasn't going to be as easy as pointing out she had no right to be there. She had methodically built, on paper, exactly enough apparent legal rights to make this expensive, slow, and genuinely uncertain. I sent a certified letter demanding she vacate within 30 days. She never responded. I paid for a process server to deliver a formal notice to quit. She responded to that one not by leaving, but by filing a response with the county asserting a valid life estate interest, and separately by changing the locks on the house. I remember standing in the driveway of the house I grew up in, physically unable to get through my own mother's front door, while Denise Whitfield watched me from the front window with what I can only describe as mild irritation, as if I was the one being unreasonable. Now, I have to tell you how she covered her tracks, because the sophistication of it still unsettles me. She hadn't just forged a couple of documents, she had built an entire paper story designed to survive scrutiny. The mobile notary she'd hired was someone she had clearly worked with before. Investigators later found that same notary stamp on strikingly similar documents connected to two other elderly clients elsewhere in the Sacramento area. The LLC, Golden Years Home Solutions, had a functioning, if fairly bare bones, website describing Compassionate Senior Transition Services, a business license properly filed with the California Secretary of State, and even a handful of 5-star Google reviews, several of which investigators later determined came from accounts created the exact same week as the business listing itself. To a casual observer, to a loan officer processing a HELOC application, to a notary conducting a routine video call with a sick, cooperative woman nodding along to whatever was read aloud to her, everything looked entirely legitimate. Nothing about it screamed fraud. That's precisely the point. I also want to walk through the mechanics of the Golden Years Home Solutions LLC in a bit more detail, because understanding exactly how the money moved is part of what eventually made this case so airtight. Denise formed the LLC in November 2022, filing articles of organization with the California Secretary of State and listing herself as the sole managing member. She opened a business checking account for the LLC at a different bank than the one my mother used, which investigators later noted is a common tactic in cases like this. Using a separate institution creates an artificial gap that makes casual, informal cross-checking harder, even though formal subpoenas eventually bridged that gap without much trouble. The money didn't move in one dramatic lump sum. It moved in a series of transfers designed to look, individually, like ordinary business activity. A $12,000 transfer here described in the memo line as consulting services. A $9,500 transfer there labeled property management fee. A handful of transfers just under reporting thresholds. Raymond's forensic report ultimately listed 47 separate transactions across 9 months, and when you laid them all out on a single spreadsheet, sorted by date, the pattern was unmistakable. But viewed one at a time, scattered across 2 different banks in 8 months, each individual transaction looked mundane. That's a deliberate structuring strategy, and it's exactly why an isolated bank teller or a single loan officer would never have caught it. No one person in the financial system ever saw the whole picture except Denise herself, until Raymond built it. That's the thing about financial predators like Diane Kultas.
The scam was never really the lie itself. The scam was the paperwork constructed to make the lie audit-proof. I called the Sacramento County Sheriff's Department. The deputy who responded was polite, even sympathetic, but he told me almost word for word what I mentioned at the very start of this story. With a recorded deed and a signed lease sitting in a folder, this looked, from where he was standing, like a landlord-tenant dispute layered over a probate property disagreement.
Not a break-in, not a crime he could act on that afternoon. Civil matter. File for eviction, file in probate court to contest the deed. Before I get to that decision, I want to describe the confrontation itself in a little more detail, because I think it matters for anyone who might find themselves standing in a similar driveway someday. When I asked Denise directly, standing on the porch with a folder of documents in my hands, how long she had been planning this, she didn't get defensive the way I expected. She got calm, almost serene. She told me, in the same warm, measured voice she'd used with my mother for over a year, that she had earned the house. She listed the nights she'd stayed awake managing my mother's pain medication. She listed the appointments she'd driven to. She said, "Your mother knew exactly what she was signing. I never once forced her hand." And for one disorienting moment, standing there exhausted and grieving, I almost believed her. That's how good she was. That's the piece I think a lot of people don't understand about cases like this. The perpetrator often isn't a cartoonish villain in the moment. She was calm, sympathetic, and completely convinced of her own righteousness, which made the confrontation feel less like catching a criminal and more like arguing with someone about a disputed inheritance among family. It took me going home that night and laying every document out on my dining room table, side by side, dates circled in red pen, before the actual scale of what she'd done it stopped feeling like a misunderstanding and started feeling like exactly what it was. I want to give you a little more of that porch conversation verbatim, as close as I can reconstruct it, because I think the specific words matter. I asked her, "Denise, did my mother know what she was actually signing when she signed that power of attorney?" She answered without missing a beat. "Your mother trusted me more than she trusted her own children toward the end, Lauren. I know that's hard to hear, but it's true." I asked her, "Where did the reverse mortgage money go? Where did the HELOC money go?" She said, "Into her care, into things she needed. You weren't here every day, I was." I asked her directly, "Did you form a company called Golden Years Home Solutions?" For the first time in the conversation, she paused, just slightly, just long enough for me to notice. "That's for my other clients," she said. "That has nothing to do with your mother." That pause is the moment I knew with total certainty that everything she'd said up to that point had been rehearsed, and that the LLC was the one detail she hadn't prepared an answer for because she hadn't expected me to know it existed yet. I hadn't, in fact, fully confirmed it yet. That point, I'd found only a partial reference to it in an old piece of mail. Her own hesitation is what told me to go dig deeper. I also want to mention the moment I found the stack of mail I referenced earlier, because it's the piece that finally broke through my own denial. Buried in an accordion folder labeled in Denise's handwriting, Carol Household, I found the original closing disclosure from the reverse mortgage lender, the origination paperwork from the HELOC, and a handwritten note, clearly Denise's own reminder to herself, listing 3 dates and dollar amounts with a small check mark next to each one, matching almost exactly the withdrawal dates Raymond would later confirm independently through the bank records. She hadn't destroyed the evidence. She'd simply assumed no one grieving and exhausted enough would ever go looking for it. That miscalculation, more than any single legal maneuver on our side, is what ultimately made this case. I hung up the phone that night, sat on the floor of my own kitchen, and made a decision that changed the entire trajectory of this case. I stopped waiting for someone else to solve it for me. I decided I was going to build a case so complete, so thoroughly documented, so mathematically undeniable that no deputy, no detective, no district attorney, and no judge would ever again be able to wave it off as a civil matter. And that's when I found the actual smoking gun.
I want to walk you through exactly how I built this case, step by step, because if you ever find yourself in a similar situation, this is genuinely the roadmap that worked. Step 1, I hired a forensic accountant. This was, without exaggeration, the single best $6,000 I have ever spent. His name was Raymond Ito, a CPA who specialized in elder financial abuse cases for probate and criminal litigation. I handed him every bank statement I could obtain, every IRA statement, every piece of loan paperwork, and every scrap of correspondence I could get my hands on, using my legal standing as successor trustee of my mother's trust to formally request records directly from her bank, Golden One Credit Union, and from the reverse mortgage and HELOC lenders. Raymond didn't just confirm the $340,000 figure. He found the underlying pattern, and the pattern mattered more than the total. He mapped every transfer out of my mother's account into the Golden Years Home Solutions LLC account, cross-referenced against the exact dates Denise had legal authority under the power of attorney, and built a timeline that reveals something devastating. The pace and size of the withdrawals accelerated sharply in the 6 weeks after my mother's cancer was reclassified as terminal. In plain terms,
Once Denise understood my mother was dying, she moved faster, as though she were racing a clock only she could see. Step 2, I pulled the notary journal. Under California law, notaries public are required to maintain a detailed journal of every notarization they perform, including, for certain document types, a thumbprint of the signer. I tracked down the mobile notary. Her name and commission number were printed in the acknowledgement section of the power of attorney, and through my attorney, we subpoenaed her complete notary journal. That journal was the actual smoking gun. The entry for my mother's power of attorney signing showed something the notary herself apparently hadn't flagged at the time, but that jumped out immediately once you knew what to look for. The thumbprint field was smudged and inconsistent compared to 2 other notarizations in the same journal for unrelated clients, and the notary's own contemporaneous notes, required under California law for certain elder-related transactions, indicated the signer seemed tired, agreed to all statements read aloud by companion. That companion, listed by first name only, was Denise. More importantly, the same notary's journal showed she had notarized documents for 2 other elderly clients in 2021 and 2022, both introduced to her, according to her own notes, by a caregiver named Denise. When my attorney and I tracked down those 2 other families, one in Citrus Heights, one in Rockland, we found the same pattern almost exactly, down to the sequence of events. An isolated, ailing, elderly person, a caregiver named Denise who steadily became indispensable, a late-stage power of attorney signed under murky circumstances, and property or account losses ranging from roughly $60,000 to $210,000. We weren't looking at a single isolated theft anymore. We were looking at an active scheme with at least 3 known victims spanning at least 3 years. Step 3, social media and digital evidence. This is where the investigation became personal in a way I didn't expect. I spent 2 full weeks combing through public records and open source information, county property records, Secretary of State business filings, archived social media accounts under variations of her name, and discovered that Denise Whitfield had, in a previous chapter of her life in Ohio and later in Nevada, operated under the names Denise Coulter and Diane Whitcomb. Same face in every profile photo, slightly different name each time, and a remarkably similar pattern underneath. Caregiving work for elderly clients, followed eventually by a property or financial dispute, followed by her vanishing from that state entirely and resurfacing somewhere new. I found an old Nextdoor post from a woman in Reno, Nevada, dated 2019, warning neighbors about a caregiver who had tried to get power of attorney over my aunt and then disappeared the moment we called a lawyer. I messaged her directly. She put me in touch with an attorney in Washoe County who had handled a nearly identical case years earlier. Same operating pattern,
different name, no criminal charges ever filed, because the family, exhausted and grieving, ultimately chose to settle quietly rather than fight a drawn-out probate battle. That single piece of evidence mattered more than almost anything else we uncovered, because it established pattern and intent. This wasn't one bad decision made by a struggling, overwhelmed caregiver. This was a repeated, deliberate, interstate scheme, refined over years. I want to describe the visit to the Rockland family in a little more detail because it was the moment this stopped feeling like my private tragedy and started feeling like a genuine pattern of predation. The family was a husband and wife, both in their 50s, whose mother had died in 2022 after a similar decline involving a live-in caregiver named, of course, Denise. When I showed them a printed photo of the woman I knew, pulled from an old church directory, the wife put her hand over her mouth and said, "That's her. That's the woman who took my mother's condo." They had never filed a police report because by the time they discovered the fraud, Denise was already gone, and an attorney they'd consulted told them a criminal case without a suspect in custody was unlikely to go anywhere. They had simply absorbed the loss and moved on, the way I suspect a lot of families do when they feel like the system has no real appetite for a case like theirs. Sitting in that family's kitchen, hearing them describe almost the identical sequence of events, the warmth, the isolation, the late-stage power of attorney, the sudden claim on the property, was the moment I understood this wasn't a one-time betrayal by someone who'd made a bad decision under pressure. This was a business model. And that realization is what gave me the resolve to keep going even through the exhausting months that followed, because I understood, finally, that stopping her wasn't only about getting my family's money back. It was about making sure there wasn't a fourth family sitting in a kitchen like that one someday, hearing this same story for the first time. Step 4. Going to the right authorities in the right order. Here's something I learned the hard way. Not every agency handles every category of fraud, and approaching the wrong one first can waste critical weeks. I filed a detailed, document-heavy report with the Sacramento County District Attorney's Elder Abuse Unit specifically, not the General Sheriff's Department line, because California, like most states, maintains a dedicated prosecutorial unit for financial crimes against elders under Penal Code Section 368, which covers financial elder abuse directly and carries enhanced sentencing when the victim is over 65. I also filed a complaint with the FBI's Internet Crime Complaint Center, IC3, because a portion of the fraudulent bank transfers crossed state lines electronically, potentially implicating federal wire fraud statutes and giving federal investigators a hook to assist if the state case ever stalled. And separately, I filed a complaint with the relevant division handling real estate fraud regarding the fraudulently recorded deed, because a forged or fraudulently induced deed is legally distinct from the underlying theft. It was the mechanism Denise was relying on to try to claim permanent ownership of the house, independent of whatever happened with the stolen cash. Step 5. The near miss. I have to tell you about the moment we very nearly lost this entire case, because it's the part that still makes my stomach tighten when I think about it. 6 weeks into the district attorney's investigation, Denise, through an attorney she had hired, offered to vacate the house and, in her attorney's words, walk away cleanly, in exchange for the family agreeing to not pursue criminal charges and to release her from any civil liability for the withdrawn funds. Her attorney framed it as a straightforward resolution that would spare everyone a lengthy, expensive legal battle. I understand completely why families accept deals like that. I was exhausted in a way I hadn't known was possible. My mother was gone. The house had been sitting occupied by no one but Denise for months, quietly accumulating legal fees and deferred maintenance and stress that seeped into every part of my life. Part of me genuinely wanted to just take the house back, sign whatever paper made it over, and be done with all of it. But Raymond, my forensic accountant, said something in a phone call that has stuck with me ever since. If you let her walk away with the money, she does this to someone else's mother next year. I said no to the settlement. 2 weeks later, we nearly lost the case anyway, through no fault of our own. Denise attempted to transfer the remaining funds sitting in the LLC account, roughly $38,000 that hadn't yet been spent, into a personal account under yet another alias at a bank in Nevada, apparently preparing to disappear the way she had, according to what we now knew, at least twice before in other states. My attorney and I had, by that point, obtained a prejudgment attachment through the civil case, a court order that freezes a defendant's known accounts before trial when they're the strong documented fraud, and it was Raymond, monitoring the account activity, who caught the attempted outgoing wire the same afternoon it was initiated. The bank flagged the transfer against the existing freeze order and blocked it outright. That $38,000 never left the account. That near miss is the exact moment the district attorney's office stopped treating this as a slow-moving civil disagreement and started treating Denise Whitfield as an active flight risk with a documented ongoing financial crime. There was a second near miss I haven't mentioned yet, one that occurred slightly earlier in the investigation and taught me something important about how these cases can quietly fall apart. In August 2023, shortly after I first filed my report, I was told informally by an intake officer that without a criminal restraining order or an emergency probate filing, Denise could legally continue living in the house and even, theoretically, list it for sale using the fraudulent deed while the dispute worked its way through the courts. That possibility terrified me. If she had managed to find a buyer willing to close quickly, possibly at a discount before the list pendants was formally recorded against the title, a portion of the stolen equity could have been laundered through a legitimate real estate transaction and become far harder to claw back. My attorney filed an emergency ex parte motion, a request heard on an expedited basis without the usual advance notice to the other side, specifically because of the risk of irreparable harm, to record the list pendants immediately. The judge granted it within 72 hours. Looking back, that 72-hour window may have been the single narrowest point in the entire case. If she had listed the house even a week earlier, the legal picture could have been dramatically more complicated. I mention this because it's a piece of practical advice worth repeating on its own. If you are ever contesting a fraudulently recorded deed, recording a list pendants should happen as early and as urgently as your attorney can manage it, even before you have the rest of your case fully built. It doesn't require proving the whole fraud. It simply requires showing the court a real good faith dispute over title exists, and it can be the single fastest, cheapest legal action that prevents a predator from cashing out before you're ready to stop them. I also want to give credit where it's genuinely due, because this case did not succeed on my efforts alone. Once the DA's office assigned a detective, Detective Marisol Herrera from the Sacramento County Elder Abuse Task Force, the investigation changed character entirely. Detective Herrera had handled financial elder abuse cases for nearly a decade, and she was the one who requested formal subpoenas for Denise's own personal bank records, something I had no legal authority to do on my own. Those records showed the LLC funds being distributed into at least 4 other personal and business accounts under Denise's various aliases, including the account tied to the informal investment club I'll describe shortly. Detective Herrera was also the one who coordinated with Washoe County to obtain the Nevada case file, formally connecting the 2 jurisdictions for the first time and establishing on the record that this was a repeat offender with an interstate pattern rather than a one-time lapse in judgment. I want to be candid about something else too. Building this case required me to essentially become a part-time paralegal for almost a year. I kept a single binder, I still have it, organized by date with color-coded tabs for banking records, notary documents, county filings, witness statements, and correspondence with Denise's attorney. Every time I found a new piece of evidence, I logged it with the date I found it, the date it was created, and a short note on where it fit into the broader timeline. Detective Herrera told me, near the end of the investigation, that the organization of that binder alone probably saved the DA's office several weeks of work, because most of the documentary case had effectively already been assembled before it ever reached the prosecutor's desk. If you ever find yourself doing something similar, I cannot overstate how much a simple, obsessively organized paper trail matters. Prosecutors are busy. Detectives are stretched thin across dozens of open cases. The more work you do connecting the dots yourself with dates and sources clearly labeled, the faster your case moves through a system that is, frankly, not designed to move quickly on its own. Denise Whitfield, Diane Marie Coltaz, was arrested on December 12, 2023, on charges including financial elder abuse, forgery, grand theft, and identity theft. Case number CR 2023-118732. And that's when, after almost a year of feeling like I was screaming into a void, everything finally started moving fast. I need to slow down here because the legal process that followed took another 11 months, and I want to give you the real shape of it, not a highlight reel. The District Attorney's Elder Abuse Unit filed formal charges under Penal Code Section 368, subsections covering financial elder abuse, which in California applies enhanced penalties whenever the victim is over 65 and the loss involves someone in a position of trust. Exactly the circumstance created by a live-in caregiver holding power of attorney over a dying client. She was also charged with forgery under Penal Code Section 470, covering both the power of attorney document and the quitclaim deed, and with grand theft under Section 487, given that the total loss vastly exceeded California's $950 grand theft threshold by a factor of hundreds. On the civil side, my attorney and I pursued 3 tracks at once, in parallel with the criminal case. First, a probate court action to void both the power of attorney and the quitclaim deed on the grounds of undue influence and diminished capacity. Undue influence being a well-established legal doctrine describing situations where a vulnerable person's free will is effectively overridden by someone in a position of trust. Second, a civil suit against Denise personally and against Golden Years Home Solutions, LLC, for conversion, the legal term for civil theft, along with unjust enrichment. Third, we recorded a lis pendens against the property itself, a formal legal notice that alerts anyone checking county records that the title is under active dispute, which effectively froze her ability to sell, refinance, or further encumber the house while the case worked its way through the system. The forensic accounting report Raymond prepared became the backbone of both the criminal and civil cases simultaneously. It's worth saying clearly because it's the single most useful thing I can pass along to anyone in a similar position. Prosecutors love a clean forensic accounting report because it turns a vague, hard-to-prosecute feeling of something seems very wrong here into 47 specific transactions, each one dated, sourced, and directly cross-referenced to a document Denise personally signed in her capacity as agent. A case like that doesn't rely on 12 strangers on a jury simply believing my word over hers. It relies on arithmetic, and arithmetic doesn't have a motive to lie. I sat through 2 pretrial hearings before the plea was finalized, and I want to describe what that process actually felt like, because it's rarely what people expect from television. There was no dramatic cross-examination, no gasps in the gallery. It was mostly quiet, procedural, almost bureaucratic. Attorneys exchanging discovery, the judge setting new hearing dates, Denise sitting at the defense table in a gray blazer, saying almost nothing. The tension lived entirely in the paperwork being exchanged outside the courtroom, in the discovery packets Raymond's report became a core part of, and in the plea negotiations happening in hallway conversations I wasn't present for, but heard about secondhand from the prosecutor, a deputy district attorney named Priya Nair, who had been assigned the case after Denise's arrest. Priya told me, in a phone call about a week before the final hearing, that Denise's defense team had initially pushed for a plea to a single lesser forgery count with probation and no prison time, framing the case as a caregiving relationship gone complicated, rather than a premeditated fraud. Priya's response, relayed to me almost verbatim, was that the forensic accounting report and the notary journal made that framing untenable because premeditation doesn't require a defendant to admit intent out loud. It can be demonstrated through the LLC formation timing, the structured cash withdrawals, and the near-identical pattern in 2 prior, independently corroborated cases. Once Denise's attorney reviewed the full discovery packet, including the connection to the Nevada case, the negotiations shifted quickly toward the plea that was ultimately entered. In October 2024, facing a criminal trial that her own defense attorney reportedly described in a pretrial hearing as carrying significant documentary exposure, Denise accepted a negotiated plea. She pled guilty to felony financial elder abuse and forgery. As part of the plea agreement, she was sentenced to 4 years in state prison in order to pay restitution in the full amount of $340,000 plus statutory interest through a restitution order enforceable as a civil judgment for the following 10 years. Which means that even years from now, a portion of any future wages, tax refunds, or newly acquired assets can be legally garnished toward that debt. On the civil side, the probate court voided both the power of attorney and the quitclaim deed outright, ruling explicitly that they had been obtained through undue influence exerted on a person of diminished capacity, meaning the house was, legally and unambiguously, once again part of my mother's estate, and by extension, mine and my brother's. We got the house back. We got the $38,000 that had been frozen in the LLC account released directly to the estate. The reverse mortgage company and the HELOC lender, once formally presented with the criminal conviction and the forensic report demonstrating that the loans had been fraudulently originated by someone exploiting a power of attorney obtained through undue influence, agreed, after months of internal review by their legal departments, to void the loans against the property entirely, treating the loss as fraud originating on their end rather than debt owed to my mother's estate. That single decision recovered the remaining roughly $205,000 that hadn't already come back through the frozen account or the restitution order. By March of 2025, every dollar of the $340,000 had either been recovered directly, formally voided by the lenders, or converted into an enforceable restitution judgment against Denise personally. I want to be fully honest with you here. The restitution judgment doesn't mean I've been paid back in cash in full, sitting in an account somewhere. She's in prison. Investigators believe most of the actual cash was spent astonishingly quickly. But the judgment itself never expires. It continues accruing interest and it follows her permanently. If she ever works again, inherits anything, or acquires property in the future, the state has the legal standing to attach it. Now, the twist, because I know you've been waiting for it the whole time. What did she actually do with $340,000? This is the part investigators pieced together during the sentencing process, and honestly, it's stranger than the theft itself. Diane Coultas hadn't simply spent the money on herself, though a real portion did go toward personal expenses, a leased Mercedes, a rental condo in Roseville under one of her aliases. But a significant chunk, roughly $140,000, had gone into what investigators described as a small, informal real estate investment club she personally ran, promising a handful of other people, mostly fellow caregivers and casual acquaintances, guaranteed returns of 12 to 15% by pooling money into property flips that, according to the state's own investigation, either never actually existed or were dramatically oversold beyond any real value. In other words, the money she stole from my dying mother was, in part, being funneled directly into what structurally resembled the early stages of an affinity Ponzi scheme aimed at an entirely different set of victims. She wasn't only a caregiver who stole from one family, she was actively recruiting a second layer of victims, using my mother's stolen money as her own seed capital to do it. That detail is a significant part of why the district attorney's office pursued this case as aggressively as they ultimately did, and it's part of why, whenever Diane Coultas is eventually released, she will be doing so as a convicted felon carrying a permanent restitution order, a public court record under her real legal name, and formal restrictions preventing her from working again in any caregiving or fiduciary role. I also want to update you on the 2 other families we discovered during the investigation, because their outcomes matter as much to me as my own.
The family in Rockland, whose losses totaled roughly $210,000, was able to use the forensic report and notary journal evidence from my case as supporting documentation in their own separate civil action, since much of the pattern evidence, the same notary, the same LLC structuring technique, the same isolation tactics applied directly to their situation as well. Their case settled in early 2025 with a partial recovery through their own homeowner's title insurance policy, which covered a portion of the loss tied to the fraudulent deed specifically. The family in Citrus Heights, whose losses were smaller, roughly $60,000, chose not to pursue a separate civil action, but was listed as an additional named victim in the criminal sentencing, which increased the restitution total in the criminal case to reflect all three families combined, bringing the total court-ordered restitution obligation against Denise across all victims to just over $610,000. I want to explain restitution enforcement a bit further because it's genuinely useful information and not something most people understand until they need it. A criminal restitution order in California functions, once entered, essentially as a civil judgment that never expires and continues accruing interest at 10% annually until paid in full. It can be enforced the same way any civil judgment can: wage garnishment, bank levy, liens against future property, and interception of state tax refunds. The California Victim Compensation Board can also assist victims in enforcing restitution orders even years after sentencing. It is not a fast process, and for many victims, especially those without a documented recoverable asset, like our house, it may never be paid in full. But it is a permanent, growing legal claim against the person who harmed you. And prosecutors and victim advocates both told me repeatedly throughout this process that pursuing the restitution order, even without full expectation of immediate payment, matters, both practically in case her financial circumstances ever change, and symbolically as a formal, permanent acknowledgement by the court of exactly what was taken and from whom. I want to describe the sentencing hearing itself because it's the moment I'd been waiting for without fully realizing how much I needed it. It was held in a Sacramento County courtroom in November 2024, and I was given the opportunity to deliver a victim impact statement before the judge issued the sentence. I had written and rewritten that statement probably a dozen times, trying to find language that captured what 14 months of this had actually cost my family. Not just financially, but in the ordinary, quiet ways grief gets stolen from you when it's tangled up in a legal fight. I told the court that I never got to properly clean out my mother's closet, sit with her belongings, or grieve her in the house she raised me in because that house was occupied by the person who had been stealing from her the entire time she was dying. I told the court that my brother and I spent what should have been a year of remembering our mother, instead learning terms like lis pendens or prejudgment attachment. Denise did not look at me during the statement. She looked at the table in front of her the entire time. The judge, in handing down the sentence, specifically cited the existence of the two other victims uncovered during the investigation, the families in Citrus Heights and Rockland. Aggravating factor, noting on the record that this was not an isolated lapse, but a demonstrated, repeated pattern of exploiting vulnerable elderly clients over multiple years and multiple states. That judicial finding mattered enormously, both practically because it supported the length of the sentence, and personally because it meant a court had formally, publicly recognized that what happened to my mother wasn't an unfortunate one-off dispute between a family and a caregiver, but a crime with a clear pattern and clear intent. We sold the house in early 2025. My brother and I split the proceeds according to my mother's original trust, the one she wrote back in 2016, long before any of this began, back when the only thing she was planning for was a quiet retirement in the home my father built with his own hands. Before I close this out, I want to tell you where things stand today, because I know a lot of you following stories like this want to know what life actually looks like on the other side of a case like this, once the cameras
figuratively speaking, turn off and the court filings stop arriving in the mail. Denise is currently incarcerated at the Central California Women's Facility with an anticipated release date in 2028, assuming standard credits. I do not visit her, and I don't intend to. My brother and I did agree, after a long conversation, that if either of us is ever contacted regarding parole hearings, we will submit victim impact statements opposing early release, a right California law explicitly grants to victims of felony crimes, including financial elder abuse under Penal Code Section 368. The house sold for $672,000 in February 2025, slightly above its earlier appraised value, to a young family with 2 kids who, when they walked through during the open house, told the agent it reminded them of the house they grew up in. I found a strange kind of peace in that. My father built that house to hold a family. For 14 months, it held something closer to a hostage situation. Now it holds a family again, and I think, in a strange way, that's the ending my mother would have actually wanted, more than any specific dollar figure ever could have been. I also want to say something about the process of writing and researching this story for you, because putting it together forced me to revisit documents and dates I'd otherwise tried hard not to think about. I don't say that for sympathy. I say it because I think it's important for anyone watching this who is currently in the middle of a similar fight to hear. It does end. Not quickly and not without real cost, but it ends. The version of me sitting on my kitchen floor in October 2023, convinced the system would never take this seriously, could not have imagined sitting here now, having gotten every dollar accounted for and a felony conviction on the record. If you are in the middle of your own version of this fight right now, I want you to hold on to that. I think often about the version of myself from the spring of 2022, exhausted, grateful, relieved that someone competent and warm had walked into our lives at exactly the moment we needed help most. I don't think less of that version of myself for trusting Denise. I think grief and fear are precisely the conditions predators like this are trained to look for, and precisely the conditions that make good, careful people skip steps they would never normally skip. So here is what I want to leave you with. The warning signs I genuinely wish someone had told me back then. First, any caregiver who steers you away from a licensed agency, away from a written contract, or away from paying through traceable methods is steering you away from the exact systems designed to protect you and your family. Cash-only arrangements aren't automatically malicious on their own, but they are absolutely a red flag worth taking seriously, especially combined with anything else on this list. Second, if a caregiver, a new friend, or any non-family member begins discouraging visits from family, gradually positioning themselves as the only one who really understands what your loved one needs, that is a documented, well-studied pattern in elder isolation tactics. Isolation is almost always step 1 in cases like this. Third, any request to sign a power of attorney, a deed, a trust amendment, or any significant financial document should go through your own independent attorney, one you selected yourself, never one recommended or arranged by the person who stands to benefit from that document. A 5-minute mobile notary signing at a kitchen table, arranged and paid for by someone other than the signer, is a massive warning sign. Real estate transfers and powers of attorney deserve genuine legal review every single time. Fourth, if you're the adult child of an aging parent, get read-only access to their accounts and set up transaction alerts now, well before any crisis hits. Most banks and credit unions will let you establish view-only access or real-time alerts without your parent surrendering any independence whatsoever. I didn't set any of this up until after $340,000 was already gone. Please don't be me. And fifth, if something feels even slightly off, start documenting it immediately, in writing, with dates. Save every text message, every email, every strange or inconsistent conversation. I didn't start keeping a real, organized file until months after my instincts first told me something was wrong, and that gap in time cost me months I can never get back. I want to add 2 more practical steps because I've heard from enough of you in the comments on other videos to know these questions come up constantly. Sixth, if you suspect a power of attorney or a deed may have already been signed, you can typically request a copy directly from your county recorder's office, often for a small fee, without needing an attorney to get started. Property records are public. Checking whether a deed has been recorded against a family member's home takes maybe 20 minutes and could save you months of uncertainty.
Seventh, if you're worried about a caregiver relationship that already feels too close, too controlling, or too financially entangled, both Adult Protective Services and your local area agency on aging can conduct a welfare check and, if warranted, open their own independent investigation, separate from anything you pursue privately. You don't need proof of a crime to make that call. You need a reasonable concern, and that's a much lower bar than most people assume. I also want to leave you with some context on how common this actually is, because I was genuinely shocked to learn it. According to figures the National Council on Aging and various state adult protective services agencies have published in recent years, financial exploitation of elderly Americans is estimated to cost victims tens of billions of dollars annually nationwide. And the overwhelming majority of cases are never reported at all. Often because the victim is embarrassed, because the perpetrator is a trusted family member or caregiver, or because, as happened to me initially, the first responding officer treats it as a civil matter rather than a crime worth investigating. Older adults are targeted specifically because they're statistically more likely to have accumulated home equity, retirement savings, and especially after the loss of a spouse or a serious diagnosis, periods of real isolation. None of that is a coincidence. It's the exact demographic profile predators like Diane Kultas are trained, whether formally or through years of trial and error, to identify and exploit. If you take away only one thing from this story, I hope it's this. A civil matter is not the same thing as nothing can be done. It just means the first person you talk to may not be equipped or authorized to be the one who solves it. Keep going. Find the forensic accountant, find the elder abuse unit, pull the notary journal, record the list pendants. The system does have tools built for exactly this kind of theft. They're just scattered across different offices, different agencies, and different specialists. And it is, unfortunately, usually up to the family to be the one who connects them. If you've been through something like this yourself, a caregiver, a contractor, a friend who found their way into your family's finances, I genuinely want to hear about it. Tell me what happened in the comments below. Where are you right now in the process? Still fighting it, already recovered, or just now starting to realize something was wrong all along? This community has helped other viewers figure out their next legal step before, and sharing your situation might help someone else who's scrolling through these comments at 2 in the morning, trying to figure out if what's happening to their family is even real. If this story was useful to you, subscribe, because next week I'm covering a case involving a fraudulent contractor who collected $190,000 in deposits from 11 different families in the same Sacramento suburb, and how one homeowner's meticulous spreadsheet ultimately brought down the entire operation. Until then, protect your paper trail. In cases like this, it's the only witness that never lies.